Hello, everyone, and welcome to another edition of Employment Law Q&A. My name is Alex Lucifero. I'm an employment lawyer and partner at Samfiru Tumarkin, LLP. We are the employment lawyers in Ontario, Alberta, and British Columbia. If you are dealing with any kind of issue related to your workplace, maybe you've been let go from your job and you've been offered some sort of severance package, maybe you haven't been offered any severance at all, having been let go, or even any other issue dealing with your employment. If you are being mistreated at work, if you feel like you're being bullied or harassed at work, or maybe your employer is changing the terms of your employment, maybe you're being demoted or you're being offered a change, some sort of change in compensation. Really, any issue that you're struggling with when it comes to your workplace rights, this is what we are here to deal with today. This is a live Q&A. I'm here to take your questions when it comes to any workplace issues. And I promise if you ask your question, you will feel a lot better having received an answer, knowing what your rights are, knowing what options you have in the circumstances. So please, again, if you're dealing with an employment issue, or for that matter, a disability insurance related issue, if you are off on a medical leave of absence and you're having difficulties with your insurance company, or you're having difficulties with your employer when it comes to disability insurance or sick leave, by all means, go ahead and ask your question. We're going to be live on air for the next half an hour, fielding questions, answering those questions, problem solving, and providing options. This is what we're here to do for the next half hour. So please, if you're tuning in just now, again, this is a live Q&A. Go ahead and post your question. I promise I will get to it before the end of the live stream. Before we get headed into the questions, a couple of things. Number one, if you are looking to contact us offline, if maybe you're a little bit too shy or bashful to ask your question online and you want to give us a call at the office, I'll give you a couple of pieces of contact information. Number one, our website address. Employmentlawyer.ca is where you should start if you're having issues at work and have some questions or concerns. Go ahead and visit our website, employmentlawyer.ca. We have a ton of resources online, video clips, articles, blog posts, employment law essentials, disability insurance law essentials, you name it. If you want a starting point with respect to your issues, go ahead and visit our website. Of course, we also have our contact information on our website if you want to reach out to us directly there. Otherwise, very simply, you can email us. Send us an email right now, help@employmentlawyer.ca. You can see the address right now on your screen. It's help@employmentlawyer.ca. Go ahead and send us an email. It's completely confidential. Give us a brief description of the situation that you're dealing with. Let us know what problems you're having. Let us know what your employer is forcing you to do or asking you to do or suggesting, or again, maybe you've been let go. Go ahead and let us know that you've been let go, and provide us some brief information about your years of service, perhaps your position, etc. And I promise you, someone will get back to you. If you email us at help@employmentlawyer.ca, we will contact you back and give you the information that you need, or alternatively put you in touch with one of our employment lawyers to help you on your way to resolving whatever issue it is that you're dealing with. If you want us to give us a call, if you want to give us a call, you can contact us toll free. The number is on your screen right now. Call us at the office. We have an entire intake team standing by to take calls, answer questions, and again, put you in touch with an employment lawyer or paralegal for that matter, depending on your situation. And that is certainly another way to contact us. You can also leave us a message, of course. And again, like our emails, we absolutely will get back to you. A couple of other issues. Now that you have our contact information, and again, feel free to reach out to us offline, so to speak, and get in touch and get those questions answered. But for now, again, this is a live employment law and disability insurance law Q&A. Go ahead and post your questions. I also I see a couple that have come up already, and that's great, guys. Go ahead and post your questions right now. Let's line a few up. Let's line a few questions up to get the ball rolling. But first, I did want to talk about a couple of matters that have been in the news this week, and I think two of these matters, and I'll deal with them quickly, speak to situations that a lot of employees are dealing with. The first one relates to RBC, the Royal Bank of Canada, quite a large employer in Canada, recently has announced that it's recalling its employees back to the office. So this is for employees in their office spaces, not necessarily kind of bank employees, tellers and branch managers and financial advisors and whatnot. But for office employees, RBC is now, 3 weeks or 3 years rather after the start of the pandemic, more or less, is now recalling employees back to the office, kind of post COVID. And it is a question that we are fielding quite a lot. It seems that a lot of large employers are actually are now recalling employees back to the office. As someone who's coming to you live from Ottawa, Ontario, I could tell you the federal government here in Ottawa has already recalled its employees back to the office. There's actually been quite a dispute between the Federal Public Service and the Government of Canada, the employer, with respect to that issue. So I wanted to touch on that in a little bit more detail. And here are kind of the broad strokes when it comes to an employer's ability or its right to recall employees back to the physical workplace after employees have been working remotely for, at this point, years. If it was clear, if the employer made clear from the very beginning, from the start of COVID, that working from home was always going to be a temporary circumstance. It was going to be a temporary solution to the issue of COVID and physical distancing and all of that stuff, and that it was always expected and made clear that employees at some point in the future would be returning back to the office. So again, if this measure was always very clearly defined as temporary, then as much as we might love our remote work environment and working from home and not having to do the commute, it does need to be said that the employer does have the right to require employees to return back to the office. Again, this is if it was made clear that this was a temporary measure. An employer is going to have the right to return employees back to the office place. I can tell you that a lot of employers are now implementing hybrid work arrangements. RBC might be one of them, where you can kind of work from home part of the week, but then work in the office part of the week. Lots of employers are doing it that way. But an employer would still have the right, if you were working 9 to 5, Monday to Friday, in the office every single day. And again, the work from home, remote work measures that were put in place were always deemed to be temporary and always very clearly communicated as temporary. Then again, your employer has the right to recall you back to the workplace. Now, for those employees that have been working from home indefinitely, maybe even before COVID, or if even after COVID, it was agreed upon that this remote work, this working from home term of employment was now going to be permanent, well, that's where the analysis changes. If you effectively had an established term of employment that you were going to be working from home or working remotely, and this was understood to effectively be indefinite, it was not a temporary measure, it was effectively a permanent measure, well, then you as an employee do have the right, actually, to insist that that term of employment continue. Your employer doesn't have the right to call you back to the workplace, at least without significant notice. If, again, that term of employment, if that remote work situation was, again, kind of permanent or indefinite. This applies to many employees who are working from home even before COVID ever happened. And I've seen lots of these situations where even, I spoke to an employee just last week, actually, that has been working from home for 10 years. Right? And their employer is now requiring them to return back to the office. That's a situation where actually that employee has a high degree of right, a high degree of protection to say, no, actually, I'm not agreeing to return back to the office. This is a permanent term of my employment. So it really depends on whether that remote work environment was deemed temporary or permanent. If it's temporary, the employer has the right to recall you back to the office. If it was permanent and even predated COVID, then you could stand your ground as an employee and continue to insist on that remote work. And that was issue number one I wanted to discuss. I see a good amount of questions being lined up. So Lauren on Facebook, JR, Gregory, Daryl, thank you so much for your questions. For those of you just tuning in, this is a live employment law and disability insurance law Q&A. My name is Alex Lucifero. I'm an employment lawyer and partner with Samfiru Tumarkin LLP. We are the employment lawyers in Canada, specifically in Ontario, the province of Alberta, and British Columbia. If you have a question about employment law or about a medical leave of absence or disability insurance, if you're dealing with a problem at work and you're tuning in, go ahead and post your question online. You don't need to mention who your employer is. You don't need to provide any confidential information. Ask it in a very generic way, and I promise I will get to your question before the half-hour mark. We're about 12 minutes in now. I will get to your question, and I can guarantee you, you will feel better knowing the way the law works in your particular case, and what your options are, or at least what the factors at play are when it comes to your situation. The law cannot help you. Our employment laws in Canada are actually quite protective of employees, but the law cannot help you if you don't know the way the law works. And so it's important that you get that information. It's important you understand what your rights and obligations are as an employee, or for that matter, if you're an employer and you're tuning in and you're wondering about a particular employee or about what obligations you have as an employer, maybe when it comes to severance, for example, go ahead and post the question. And I promise I'll get to it. All right, very quickly, second factor I wanted to discuss deals with severance. And I'll make this quick because I want to get to the questions. We are continuing to hear, I mean, it's been weeks and weeks and weeks, really since the start of the year, if not the end of last year. We continue to hear on a weekly basis of large employers terminating employees, reorganizing, and it's led to lots of layoffs, mass layoffs in some cases. Amazon is a recent example of that. They just announced again, and I think this is the second or third announcement over the course of the past several months, where they're laying off a few thousand employees. I want to remind all employees out there, and again, for those of you tuning in, make sure if it's you in the situation, or if you have a friend or a family member that has lost their job, that is a situation where you absolutely need to get employment law advice. You need to speak to an employment lawyer if you have been let go. Do not assume that what your employer is offering you as severance is correct. Lots of employees will falsely assume that the company must be doing what's legal, or they must be making me a fair offer, when in fact that is oftentimes, if not almost always, I would say, not the case. Keep in mind, when it comes to termination of employment and it comes to severance, the employer is going to be looking out for its own best interests. They are looking to minimize as much as possible what an employee is going to receive as severance when they're let go. And so almost always we see severance offers that are far less than what an employee is actually owed based on their age, position, and years of service. So again, do not assume that what your employer is offering you as a severance package is correct. You can be leaving tens of thousands of dollars on the table if you blindly sign off on a severance offer. Do not be that person that leaves that kind of money on the table. You need that money to be financially secure, to secure your your family rather, their financial interests, and to make sure that you have enough time moving forward to find that next job. Make sure that if you are let go from your job, or if a colleague or a family member or a friend is let go from their job, tell them they need to speak to an employment lawyer, and tell them they could visit employmentlawyer.ca to find out what their severance entitlements are and speak with an employment lawyer. And again, you can contact us off air, email us, visit our website, give us a call, however you want to get a hold of us. Send a courier pigeon. Right? Make sure that you're speaking with an employment lawyer before you decide what to do with a severance offer. All right, with that out of the way, let us get to the questions. Everyone, again, thanks so much for those of you who have already posted your questions. It is not too late. If you're just tuning in, this is a live employment law Q&A. Go ahead and post your question, and I promise we will get to it before the end of the segment. But without further ado, Gregory was first in line. Gregory, thank you so much for your question. Gregory on Facebook asks, I was just let go a week after my probationary period ended. I was given 2 weeks severance, but I'd left the previous job for this one that I'd been at for almost 7 years. Gregory, you don't really ask a question, but I appreciate the context. I can tell you, if you're beyond the probationary period, 2 weeks of severance is almost certainly insufficient, regardless of the fact, Gregory, that you're probably not even a year into that new position. I could tell you for a fact that short-term employees, I actually spoke to a lady just this morning who was employed for only 9 months with the same employer and has significant severance entitlements. Even short-term employees that haven't even been with the employer for a year are entitled to significant amounts of severance. Even just setting aside the issue of your previous employment, Gregory, as a even 3 or 4 or 5 or 6 or 7 or 8 month employee, you can be owed anywhere between 3 and 6 months of severance, depending on your age and the position that you held with the company. So you might be owed as much severance potentially as the time that you actually worked at the same employer, if not very close there too. So 2 weeks, in my mind, Gregory, even despite knowing your age or your position, and by the way, feel free to post those, and I'll give you a more specific answer there with respect to your severance entitlements, because the analysis is based on age, position, and years of service. 2 weeks is likely not enough severance for somebody even that was with an employer for less than a year. If I can add on top of that, Gregory, if you were recruited away from your previous job and you were in secure employment and you said you were with that previous company for 7 years, if you were actively recruited away to join this new employer and were then let go only a few months afterwards, that is another factor that's going to be taken into consideration to extend your severance entitlements. Right? The fact that you were recruited away from secure employment may very well extend your severance entitlements as well. So, right off the bat, Gregory, I think 2 weeks is insufficient. What I would recommend is give us a call, send us an email at help@employmentlawyer.ca. Let's review the documentation. Let's have a chat. The good news, Gregory, is that these severance matters are oftentimes very, very easy to resolve. Oftentimes, with a few conversations or sending an initial letter to an employer, these matters can be resolved quite straightforwardly after only a matter of weeks. We're not talking about a long, protracted, complicated legal matter here. Most of these matters, at least, are quite straightforward to resolve. All right, JR is next up in line, and JR on YouTube asks, what are the time stipulations for filing a claim against a former employer based upon the pretense of a constructive dismissal? Very interesting question, JR, and there are two kind of timelines here that come to mind. Number one, when we're dealing with an employment issue generally, and this applies to most kind of legal proceedings, ultimately an employee has 2 years from the date that they were let go to commence formal legal action. So generally speaking, this is what we call a limitation period. A claim must be commenced, must be filed with the court no later than 2 years from the date of termination. So that is one deadline, JR, that I would keep in mind here. If it's already been more than 2 years, you are effectively out of time. You have your limitation period has expired when it comes to your matter. Now, when we're talking about constructive dismissal claims specifically, a constructive dismissal, for those of you tuning in that don't really know what that means, a constructive dismissal is effectively a breach of contract. So when an employer tries to make a significant change to the terms of your employment, let's say they decide to temporarily lay you off, or they decide to demote you, or cut your pay, or change your job responsibilities in a very significant way, that is potentially a breach of contract. That is potentially what we call a constructive dismissal. It would allow the employee, in response to that change, that major change, it would allow them to claim that they have been terminated, seek their severance entitlements, and get moving on with their lives and with new employment. Oftentimes, claiming constructive dismissal in the face of a major change is the best option that the employee has. Accepting a major change has potentially very serious and negative ramifications for the employee moving forward. You don't want to accept a temporary layoff as part of a term of your employment moving forward. You don't want to accept a pay cut necessarily. You'd rather claim termination, get your full severance entitlements based on your full compensation, right? Or treat the temporary layoff as a permanent termination and get your severance entitlements. Now, JR, you asked the question, right? Are there any time stipulations when it comes to constructive dismissal? Well, actually, yes, there is, and they don't necessarily relate to the 2-year limitation period issue. What they relate to is the fact that when you're dealing with a change to the terms of your employment, right? For example, if your employer temporarily lays you off, right, and sends you home without pay, the longer that status quo continues, the weaker your constructive dismissal claim becomes. You don't want even months to pass, right, when there's been such a change, because that silence on your part may be deemed an implicit acceptance of that new status quo. So, for example, again, I'll use the example of a temporary layoff because it's the most simple of constructive dismissals. If your employer temporarily lays you off and you say nothing and go home and just wait to be called back to work, and several months pass, right? Let's say 3 or 4 or 5 months pass. At that point, time is of the essence. It may be the case that your employer will be able to say, well, you implicitly accepted the change by staying home and not saying anything about it. And so if you're dealing with any kind of major change to the terms of your employment, again, a pay cut, a position change, a temporary layoff, again, maybe your job responsibilities have changed in a significant way. The moral of the story here is that you need to act quickly. You need to speak to an employment lawyer as quickly as possible. I'm not saying it has to be done within a matter of days. You probably have a number of weeks, right? But the longer time goes by, potentially the weaker your constructive dismissal case becomes. There is no bright line rule here that says you have to act within a week or within a month or even within 2 months. But I can tell you for certain, the sooner you act, the better. And so, JR, if you're dealing with a potential constructive dismissal situation, that is the best advice I can give you. Whatever time has already passed, the sooner you act, the better. If it's been years or if it's been several months, listen, you still want to get employment law advice, but your case is not getting stronger as time goes by. Your case is likely getting weaker. All right, let's keep the ball rolling here. Next in line is Lauren on Facebook. Lauren, thank you so much for your question. Lauren asks, I was told I don't qualify for severance as I was employed through a temp agency. Is this true? Great question, Lauren. Temp agencies are becoming more and more popular. Dealt with a situation similar to this just last week. And Lauren, that is absolutely false. You are undoubtedly owed severance despite the fact that you were worked through a temp agency. You are an employee like anyone else, like any other employee, despite the fact that you work through a temp agency. If your employment has been terminated, if you are no longer employed by the company or by the temp agency's client, whoever it was you were working for, that's a termination like any other, Lauren, in which case you would be owed severance. Severance is going to be based on your age, position, and years of service. The longer you've worked for the company, the older you are, the more senior your position, the more severance you are going to get. It may also be important to look at any employment contracts or employment agreements that you have that might speak to what kind of severance you might be owed. It's another factor that we'll have a look at. But an employer cannot say that you're not owed severance because you work through an employment agency. Think of it this way, Lauren, if that was the case, every single employer would use an employment agency for their employees to get away with paying zero severance. It just doesn't make logical sense. Again, you're an employee like any other. You're going to be owed severance. If you haven't been offered any severance, Lauren, that's an extremely serious situation. Listen, give us a call at the office. Again, send us an email and let's have a chat. And I promise we'll be able to resolve that situation. All right, next up, and we'll do it a bit rapid fire here, guys, only because we have a few minutes left. I want to make sure I get to all of your questions. Again, for those of you just tuning in that are curious about their situation, have a question, have an employment law issue, have a workplace issue, go ahead and post your question right now, and I'll get to it. It's not too late to post your questions, guys. Next up in line is, as we scroll down here, Joe. Joe asks, hi, my employer had a convo with me saying my job will be terminated, but didn't tell me an effective date. I was then on vacation for 2 days. And Joe continues in another post. And on the Monday, I provided a note saying I'm off for 10 days. I assume you mean a doctor's note. Joe, my boss is saying I was terminated the day of the meeting. I was not given an email or letter or the effective date of my term. Am I terminated or on sick leave? Well, Joe, that's an interesting situation because it raises a couple of important points. Now, typically, and on Ontario specifically, termination of employment needs to be done in writing. There has to be written notice of termination. That is a requirement, actually, under the Employment Standards Act. So the fact that you haven't been kind of provided written notice of termination, Joe, is a problem. Your employer needs to put that in writing. That said, if you are no longer working as of the date that you were told that your employment was being terminated and that it was effective immediately, I don't think this is an issue really that needs to be disputed. It's clear that your employer has told you that your employment has come to an end. You can certainly continue on a medical leave of absence, but it becomes a question, Joe, of how much severance you're owed, really. And actually, your medical leave at this point in time won't necessarily save you for a termination. And if that's what you're aiming for here, I don't think that's necessarily going to be the case. You may be still entitled to short-term disability benefits. You may still be considered to be on a medical leave of absence, but your employer can terminate your employment really regardless of those reasons. And it becomes a question, Joe, not of saving your job, but of how much severance you are owed in the circumstances. I say this as it applies to non-unionized employees, which are probably the majority of employees out there. If you are in a unionized position, Joe, that might be a different analysis. If you're a unionized employee represented by a union, and if you are, you may be able to get your job back if that's what you want. And if that's the case, we cannot help you as employment lawyers, whether it's ourselves or any other law firm for that matter. It is your union that can help you as a unionized employer. They are your legal representatives. You should go immediately to your union if that's the case and speak with them about the situation. They could likely file a grievance on your behalf. If you're a non-unionized employee, Joe, however, your employment has been terminated despite the fact that it's not written notice, and it becomes a question of how much severance you're owed based on your age, position, years of service, but also based on your medical status and condition. And if you're on a medical leave, that can very well extend your severance period. I would say it almost certainly does. Much appreciated, Joe, for the question. Daryl is next up in line. Daryl asks, it sounds quite interesting, actually. Daryl on YouTube says there was a fire at work on March 15th, and the building was closed for investigations and cleanup. I was offered work at 2 different locations, but refused because it was too far, 30 minutes instead of 5 to 10 minutes. I was told I could use vacation pay or choose no pay and stay home until further notice. I was not told in any form that I'd laid off, and this is the first time this has happened. Have I been temporarily laid off, and is this a constructive dismissal? Great question, Daryl, and quite a particular situation. I can't say I've come across that situation before where, obviously for reasons unrelated to you or the employer for that matter, there was a fire at work and you've been offered work elsewhere. Listen, I'll be frank, Daryl. In a lot of these situations where you're being asked to work in a different location, those situations can very well lead to a constructive dismissal. If your employer is changing office or changing location, changing, production facility, whatever it may be, and it's now an hour away from you, or because of the fact that maybe you take public transportation, the commute is going to be significantly longer. That can very well lead to a constructive dismissal. There are actually lots of cases out there that deal with this issue of geographic location, an employer changing locations, and that being constructive dismissal. So your intuition is right there, Daryl. However, I have to say, if the commute is 30 minutes instead of 10 or 5 or 10 minutes, that might not be enough for constructive dismissal. Lots of people commute 30 minutes plus to get to work. And if the difference is only really going to be about 20 minutes or so one way, I don't think that's going to be enough for constructive dismissal. So I don't know if I'd necessarily recommend you treat that as a termination or treat that as a constructive dismissal. If you were telling me the commute was going to be an hour long, I tell you, yeah, that's likely a constructive dismissal. But for an extra 20 minutes or so, I don't think it's enough, Daryl. I certainly wouldn't recommend that you kind of gamble on that issue and gamble on your severance for such what would be considered likely a minor change to the terms of your employment and a temporary change. at that. I would either, at least as a temporary measure, right, accept employment at those other locations that are 20 minutes plus away, or I'd use my vacation pay and hold myself over until there, or take no pay, perhaps, well, as perhaps a last resort. We will leave it there for today, guys. Unfortunately, we are out of time. But for those of you whose questions I didn't get to, do not fret. We have another live stream coming up at 1:30 Eastern Standard Time tomorrow. Make sure you tune in then and ask your question. For those of you who asked your questions, thank you so much. For those of you who just tuned in and were curious to learn about their employment rights, thank you for watching. My name is Alex Lucifero. We are the employment lawyers, Samfiru Tumarkin, LLP. Have yourselves a good rest of the day and a good rest of the week. And until next time, take care, everyone.